Must be shown the red card for defeating
the nomination of Justice Mohamed Warsame to the Judicial Service Commission appears to have set the three arms of government to a collision path once again. While both the executive and the legislature argue that it is within the jurisdiction of Parliament to vet Warsame, the Law Society of Kenya has argued otherwise. Last month, the High Court issued orders barring Parliament from vetting Justice Warsame, and the National Assembly's Justice and Legal Affairs Committee said its hands were tied by the ruling.
I want to say that we were not able, because of those seriousness of the Speaker, to approve the nomination of Justice Warsame.
In its report, the Justice and Legal Affairs Committee urged Parliament to stay debate on Warsame's nomination until the court pronounces itself on the matter. The MPs would, however, carry on with the debate after expunging the recommendation.
In fact, if the committee did not bring that recommendation, amendment, I was ready to file that amendment after I read this report.
The suit, in my opinion, Mr. Speaker, by the Law Society, which I respect and I'm a member, was actually sub judice to the House.
LSK has argued that the nomination of Justice Warsame and subjecting him to vetting is a violation of Section 15, subsection 2 of the Judicial Service Act.
Anybody who believes in the judiciary that a sitting judge cannot be vetted by Parliament, they should go and do something about the provisions of Section 250(2)(b).
LSK further argues that after being elected to represent the Court of Appeal in JSC, Warsame ought to have been immediately appointed by the President and not forwarded to Parliament for vetting. For Channel 1 News, I am Edward Kabasa.